And greetings. Welcome to Law of Evidence, the Best Evidence Rule from American Jurisprudence. I'd like to welcome you all here for furthering our expedition into the law of evidence. And tonight we're going over the Best Evidence Rule. Let's get right down into it here. Oops. And if you haven't already, please hit the like to make sure everyone knows that we're here and the show has begun. So, what's going on here? Oh, here we go. All right, so we're going over the best evidence rule. Generally, section 1049. The best evidence rule provides that in establishing the terms of a writing, where such terms are material, the original writing must be produced, unless it is shown to be unavailable for some reason other than serious fault of the proponent. The best evidence rule does not purport to include substitution of weaker for stronger evidence, but merely comprehends the situation where evidence offered is clearly withheld. The underlying purpose of the best evidence rule is the prevention of fraud or mistake in proof of the contents of a writing. Accordingly, the rule does not preclude a witness from testifying to facts recorded in a writing from his or her personal knowledge. Without using the term best evidence, the federal rules of evidence have adopted the best evidence rule and provide that to prove the content of a writing, recording, or photograph, the original writing, recording, or photograph is required, except as otherwise provided in the federal rules of evidence or by an act of Congress. Practice Guide. An objection based on the best evidence rule is waived if not raised during trial. Interesting there. So the objection will be waived if it's not raised during trial, if it's based on the best evidence rule. And let's see what we have here for our footnotes. As limitations on the application of the best evidence rule, see section 1050, which we'll be reviewing shortly. Let's see what else we got here. Oops. Law reviews. Nance, the best evidence principle, annotation. Here's our annotation here. Admissibility of computerized private business records. The applicability of best evidence rule to proof of ownership of allegedly stolen personal property in prosecution or theft. It's from American Law Review. We have proof of public records kept or stored on electronic computing system. And we have some other practice references here. Proof of facts, mapping the trial. Order of proof, best evidence rule from American Jurisprudence, Trials. 505, section 37. That would be an interesting one to check out. And forms, we have notice, production of original document from pleading and practice forms. So these are some interesting notice, production of original document, order of proof, best evidence rule. Nice little things in here. In an action for personal injury and property damage arising from an automobile collision, the court erred in excluding plaintiff's proffered testimony as to medical expenditures for prescriptions and medication upon the defendant's objection that the best evidence would be the receipts. Let's look at this one again. An action for personal injury, property damage. The court erred in excluding plaintiff's proffered testimony. Okay. I'm not going to pretend like I know how they're using that word. So that behooves us to look in the Black's Law here. And let's see if we can get lucky here in the scanned version and it land up right near the P's for us. Otherwise, it takes a little bit of time to catch up. So please bear with me. And as it goes through here we go, the F's. Almost there. Going a little faster than usual today, but fortunately this is a image scan document of Black's Law, so it doesn't search or scroll through very well. But it will suffice because it is a good reference here for us to get to the proper definition in this application of the word proffered. All right, we should be close now. Here we go. Interpleader. Some interesting words as we come along here. All right, there's going to be a lot of these here. Okay. Plain language law, legislation requiring non-technical, readily comprehensible language in consumer contracts such as residential leases or insurance policies. Many of these laws have genuinely simplified the needlessly obscure language in which consumer contracts have traditionally been couched. Interesting ones here. Plain meaning rule from 1937. The rule that if a writing or a provision in a writing appears to be unambiguous on its face, its meaning must be determined from the writing itself without resort to any extrinsic evidence. Though often pleaded, this rule is often condemned as simplistic because the meaning of words varies with the verbal context and the surrounding circumstances, not to mention the linguistic ability of the users and readers, including judges. Golden rule, mischief rule, equity of the statute rule. All right. Interesting little diversion here, but let's get back to where we were. Proffered. Wow, a lot of P's, huh? Okay, we're getting there now. Geez. Wow, I didn't realize how many PRI words there were. Okay, here we go. Yeah, getting close. Product, profit. Okay, so it's going to be here. 2 F's. Hang on a second. Don't tell me it's not here. There we go. Proffer. 14th century. Verb, to offer or tender for immediate acceptance. So proffered evidence, see evidence. Oh, great. Well, we're reading about evidence. So proffer means to offer. So offer or tender for immediate acceptance. Okay, let's get back to the book. Okay, an action for personal injury and property damage arising from an automobile collision. The court erred in excluding the plaintiff's proffered testimony as to medical expenditures for prescriptions and medication upon defendant's objection that the best evidence would be the receipts. So the immediate testimony there that was offered was the court erred in excluding that upon the objection that best evidence would be receipts. Interesting. So there must be some details in that case there. Federal Rule 1002 has adopted the best evidence rule with modifications geared to reconcile the rule's primary purpose with the proven accuracy of modern copying techniques. Ooh. To reconcile the rule's primary purpose with a proven accuracy. Now this looks interesting here. In Federal Rules Evidence Serve. So Federal Rule 1002 is one that has to be looked into further, huh? That's 1002. And then we have the uniform rules of evidence are almost identical to the federal rules of evidence. Uniform rules of evidence, 1002, as application of the best evidence rule. So there's for further reading. Now we're on 1050. Limitations on scope of best evidence rule. The best evidence rule applies only to documentary evidence, which includes words and symbols recorded on any tangible thing. The rule does not apply to duplicate originals of documents, nor does the rule apply to proof of the nature, appearance, or condition of physical objects. Such facts may be proved by parole evidence without the necessity of introducing the objects in evidence or accounting for their absence. Interesting here. Let's read this again here. The limitations on the scope. So, instead of the original, the best evidence rule applies only to documentary evidence, which includes words and symbols recorded on any tangible thing. That's what it includes, not limited to. The rule does not apply to duplicate originals of documents. Interesting there. Nor does the rule apply to proof of the nature, appearance, or condition of physical objects. Such facts, okay, so someone could testify that without introducing the object. I see. Bring the car into court. The best evidence rule applies, and an original is required only when a writing is introduced to prove the contents of a writing, recording, or photograph, or to establish the existence of such documents. The rule does not come into play when a party uses a document to prove the existence of an independent fact, as to which the writing is merely collateral or incidental. Additional specific limitations on the application of the best evidence rule may be provided by statute. Okay, so we're on to the supplement here. Again, this is, I believe, a 1998 edition. So this has all pretty much been, there's been a lot of updates since then, in the decades since. However, a lot of these rules of evidence are pretty much set in stone, so to speak, and there might be some other nuances that, again, these supplements here were of that time, and I'm sure there's been quite a few more since then. So, as always, just don't construe anything in this broadcast for anything legal, lawful, personal, private, business, tax, financial, or otherwise. This is strictly for the entertainment, educational purposes of this broadcast, so don't do this at home. Okay, let's proceed. The case authorities here. In suit on homeowners insurance policy. Exclusion of underwriting manager's testimony on the basis of best evidence rule was erroneous, since although witnesses' answers would have been based in part on content of insurer's underwriting guidelines, witnesses would not necessarily have been required to state contents of guidelines in order to answer question. Hence, best evidence rule was not implicated. Very interesting there. Here we get the admission of witnesses' testimony as to what they heard in a homicide. Defendants say on a television news broadcast did not violate the best evidence rule. What they heard the homicide defendants say on a television news broadcast. Witnesses' testimony as to what they heard him say on a news broadcast. That's interesting. And that's 1990, of course. As the applicability of the best evidence rule to inscribed chattels. See section 1078. So this would be an interesting one here to look at too, section 1078. Let's see if we can take a quick look over here to section 1078. Memoranda and inscriptions. The best evidence rule may apply to private memoranda to the same extent that it applies to private writings generally. And the memoranda where available, must be introduced in evidence to prove the contents of them. However, a memorandum that records a past recollection, memorandum. Here we go. There are certain writings and inscriptions which cannot be properly classified as documents, and to which the best evidence rule is not applicable, but which the law regards simply as matters of description and identity as susceptible, primarily of parole proof, such as a direction on a parcel, words written on a tag of a valise, labels attached to jugs or decanters and indicating their contents, price tags on garments, and markings on railroad cars and waybills. Under the best evidence rule, an inscribed chattel is an object which is both a writing and a chattel. It is a matter of trial court discretion as to whether or not to admit secondary evidence of inscribed chattels in the face of a best evidence objection. In addition, the best evidence rule does not extend to mere notices which persons are not expected to keep. Interesting there. Okay, because I don't think we're going to get to that part, so I wanted to take a quick diversion there so we could get an idea of what they were talking about there. Okay, so we saw that. All right, here's the Uniform Rules of Evidence, Rule 1004. The best evidence rule did not apply to witnesses' testimony that union referrals were given out unfairly, where the purpose of such testimony was not to prove the contents of the out-of-work list, but to show merely that the list was not always adhered to. Of course, refusal to require the production of promissory notes, which were the fruits of a mail fraud scheme, was proper, since the notes were only collaterally involved and were introduced not for the proof of their exact terms, but rather to show the method by which the scheme was effected. Wow, that's an interesting one there. The best evidence rule did not apply to exclude testimony concerning an insurance policy covering the victim, which was found by the testifying witness when she was collecting the defendant's personal belongings, where such testimony was not offered to prove the contents or terms of the policy, but to show the defendant's knowledge that the policy existed. A lot of insurance cases that come up in these things here. All right. Secondary evidence under expectations, the best evidence rule. All right, we're on to section 1051, effective expert testimony. In addition to the general limitation that an original is required only where the object is to prove the contents of a writing, recording, or photograph, Rule 1002 of the Federal Rules of Evidence is limited in its application by Rule 703 of the Federal Rules, which allows an expert to give an opinion based on matters not in evidence. For example, in a copyright infringement action, it was held that expert testimony could properly be used to develop proof of the defendant's gross revenues attributable to the infringement when financial records sufficiently detailed to show the infringer's profits were not available. Further, hospital records, which may be admitted under the business records exception to the hearsay rule, commonly contain reports interpreting x-rays by staff radiologists who qualify as experts, and these reports may not be excluded from the records by Rule 1002 of Federal Rules of Evidence. Interesting. Interpreting x-rays. Okay. This is a admissibility of x-ray report made by physician taking or interpreting x-ray pictures. Check over here to the chat and see what's going on with that. Not sure if it's fully refreshing or not. Test in there, make sure it's refreshing on my end. Ooh. Okay, yeah, I guess I got a little issue here. What's going on? Give me a moment here, let me find out what's going on with the chat. Wow, that's really strange. All right, give me one more moment here. We'll try this. Okay, we got some chat happening there. Pop this thing out. Yeah, I typed something into chat, Craig, and it didn't come through either. So there you are there. Okay, I see you there. I just don't see me showing up, which is fine. As long as you guys are there, and I see there's one other's missing here. Very odd. See if it'll work now. Okay, there we go. All right. Let's proceed. So we're on to Section 1052, testimony or written admission of a party against whom item is offered. Some jurisdictions follow the view that a party's own statements and admissions are admissible in evidence against that party, although such statements and admissions may involve what must necessarily be contained in some writing, deed, or record. Under Rule 1007 of the Federal Rules of Evidence, the contents of a writing, recording, or photograph may be proved by the testimony or deposition of the party against whom offered or by the opponent's written admission without accounting for the non-production of the original. This rule recognizes the risk of inaccuracy with respect to oral admissions of what a writing contains, and therefore limits the use of admissions to those made in the course of giving testimony or in writing, unless the non-production of the original is accounted for and the secondary evidence generally has become admissible under Rule 1004 of the Federal Rules of Evidence. So let's look at this here, the admissions. So we have here let's see, the admissions here is oral admissions, right, of what a writing contains as opposed to a written instrument. Okay, I get you here. So it's the inaccuracy with respect to oral admissions, since that's why the best evidence rule would typically want to see the actually written instrument, unless one of these exceptions applies, and this would be not one of those here. So we're on to the observation here that Federal Rule of Evidence 1007 does not apply where the contents of a document are sought to be proved by the testimony of a party other than one against whom such proof is offered. So don't rat on yourself. And admitting copies in lieu of original documents. Stipulation: admitting documents or copies or abstracts thereof, and waiving rule to introduction of documentary evidence. So, and then we have federal rules. Let's see here. Exceptions to the best evidence rules. Circumstances when secondary evidence is admissible. Okay, so now we kind of get the idea, the best evidence rule, that there are certain instances where it does apply and somewhere it pretty much is not going to apply. It'll be waived. So in certain situations where there might be exceptions where it won't be available or for whatever reason, the secondary evidence will have to suffice. So let's see some of these, what we'd say, exceptions to the best evidence rules and those particular circumstances where secondary evidence is admissible. So generally, Section 1053, where the original writing, recording, or photograph cannot be produced by the party whom the evidence is offered within a reasonable time by the exercise of a reasonable diligence, secondary evidence of the contents of the writing may be admissible. Basically, the rule requiring production of the original proof of contents has developed as a rule of preference, and thus, if the failure to produce the original is satisfactorily explained, secondary evidence is admissible. The introduction of secondary evidence is generally permitted where the proponent is able to show that the original is lost or destroyed, is not obtainable, or is in the possession of the opponent. In addition, a summary of the original evidence may be admitted where the original is voluminous or complicated. The determination of whether to admit secondary evidence under one of these exceptions is within the discretion of the trial court. In making such a determination, a court is not bound by the federal rules of evidence except those with respect to privileges. So privileged evidence is not admissible. Clear and convincing evidence of authenticity and accuracy of secondary evidence is not required for admission under Rule 1004 of the Federal Rules of Evidence, but rather the proponent must present a sufficient foundation so that the reasonable juror could be convinced that the secondary evidence correctly reflects the contents of the original. In jurisdictions which have adopted the Federal Rules of Evidence, the best evidence, which is pretty much all of them to some extent, the best evidence rule does not recognize degrees of secondary evidence. If available and if properly authenticated, the proponent can present more than one type of secondary evidence to prove the contents of the original writing. And it seems more might be better in that case. However, in some jurisdictions that have not adopted the Federal Rules of Evidence, where the original is not available and consequently a fact may be proved by secondary evidence, the proponent of the secondary evidence must produce the best secondary evidence which exists and which is within his or her power to produce. So some jurisdictions you may not be able to do it by volume of secondary evidence. You would have to have best secondary evidence. Term of the day. All right, admissibility of summaries of secondary evidence as to whether particular issues of fact are for the court or the jury. See section 1058, which we should be at shortly. Here's an objection to notice to produce documents, grounds, privileged communications. So it's objection for them to enter those in. Once an enumerated condition of Federal Rule of Evidence Rule 1004 is met, the proponent may prove the contents of writing by any secondary evidence, subject to an attack by the opposing party, not as to admissibility, but to the weight of the evidence. Wow. There's no requirement under Federal Rule of Evidence 1004 that a copy of a document be introduced in preference to oral testimony concerning the document. Criticized, though, on other grounds. All right, we're on to section 1054. Original was lost or destroyed, or the dog ate it. Secondary evidence of the contents of a writing, recording, or photograph is admissible where all of the originals are lost or have been destroyed, unless the proponent lost or destroyed them in bad faith. The burden of proof in establishing loss or destruction of an original is on the proponent of the secondary evidence. The proponent may be required to demonstrate some degree of diligence in the search for an allegedly lost or destroyed original in order to meet this burden. The proponent also has the burden of additionally establishing by clear and convincing evidence the existence and execution of the original writing and the contents of the writing. Section 1054, Original Lost or Destroyed Supplement. Case authorities. In prosecution for theft by deception, trial court properly admitted photocopies of checks as secondary evidence under best evidence rule, where victim destroyed checks at defendant's direction, and thus copies of checks were admissible to be replaced destroyed originals. Careful those photocopies. Let's see, holding that the loss of a copy of a document does not foreclose establishing its contents through testimony of the draftsman. Those who read the document or those who might have knowledge of its provisions. Wow. Okay, and we have here, in suit to recover compensation for non-scheduled overtime work, an employee was entitled to present as secondary evidence any admissions made by the employer where the employer lost or destroyed the records that would have documented the actual hours worked. Here's an annotation: the Federal Rules of Evidence. Admissibility. Pursuant to Rule 1004, Section 1, of other evidence of contents of writing, recording, or photograph where originals were allegedly lost or destroyed. And our practice references for the foundation for admission of secondary evidence, that's in 35 AmJur, proof of facts. We might be able to go over that one next time. I believe I have that one digitally as well. Uncontradicted testimony of agents of a real estate developing company that they could not find a contract that was adequate under Federal Rule of Evidence 1041 to establish that the original document had been lost, other than through the plaintiff's bad faith. Oral testimony of those familiar with the contract was thus admissible to prove its content. All right, we're on to section 1055. Proving loss or destruction without bad faith on part of proponent. Some courts condition the admissibility of secondary evidence upon a satisfactory showing by the proponent that the original has been lost or destroyed without bad faith, or on a finding of a sufficient basis for concluding that the originals were lost or destroyed without any bad faith on the part of the proponent. Under the Federal Rules of Evidence, the sufficiency of preliminary proof as to whether the proponent has lost or destroyed the original of a writing in bad faith is a matter of law for the court to decide, and the judge's determination as to the standard of proof applicable will not be disturbed in the absence of clear evidence of mistake amounting to an error of law. So that's your burden of proof here under Federal Rules of Evidence, the sufficiency of preliminary proof as to whether the proponent has lost or destroyed the original of writing in bad faith is a matter of law for the court to decide, and the judge's determination as to the standard of proof applicable will not be disturbed in the absence of clear evidence of mistake amounting to an error of law. Clear evidence of mistake. The absence of any evidence of bad faith on the part of a proponent may be accorded significance by the court in evaluating a show of loss or destruction of an original writing. Bad faith will not be inferred where the proponent testifies that destruction of the original in issue was due to the negligence of its employees. That's nice. Furthermore, the fact that the original was not inadvertently destroyed, but was deliberately destroyed, does not mean that the evidence is not admissible under Federal Rules of Evidence so long as the destruction was not in bad faith. Even intentional destruction in violation of law or regulations requiring the preservation of documents has been found not indicative of bad faith, so as to exclude secondary evidence of the destroyed originals. Loss or destruction of an original without bad faith can be shown by circumstantial evidence of a routine practice of destruction of documents. On the other hand, inconsistent or incredible testimony, not corroborated by any neutral or independent party, and suspicious circumstances surrounding the loss or destruction of alleged originals can give rise to an inference of bad faith on the part of the proponent and influence the court to deny admissibility. So it seems like a pretty difficult burden to prove there of bad faith. So it might not always be the best avenue to take. If a party has voluntarily destroyed a written instrument, if a party has voluntarily destroyed a written instrument, he or she cannot prove its contents secondarily unless he or she repels every inference of a fraudulent design in its destruction. Now, that's a good one there. That's Kawhi Paul Lamb versus Northern Illinois Gas Company. So this is from Illinois Appellate. This is a good case here, it looks like. If a party has voluntarily destroyed a written instrument, he or she cannot prove its content secondarily unless he or she repels every inference of a fraudulent design. That's a pretty good case right there. Might be one for the notepad. Or the clipboard, we should say. And here we go. Holding that the proponent may be required to prove to the satisfaction of the court that it is more probable than not that the originals of the writings were lost and destroyed without bad faith, where 1. There are peculiar and suspicious circumstances surrounding the discovery and production of the secondary evidence in the case, requiring a rigid inquiry, and 2. The documents at issue are the very foundation of the plaintiff's claim. That's another good one there, versus Lucasfilm too, huh? Interesting. So this is pretty good here. A lot of good cases to refer to here. Case holdings, appellate cases. All right, see here. United States versus Cambindo, Valencia. Criticize. Okay, that's okay. As to proof of loss or destruction of original, see 1054. So long as there is no evidence of any intentional conduct indicating fraud, no evidence of any intentional conduct indicating fraud, and a desire to destroy the document and thereby suppress the truth, secondary evidence of a deliberately destroyed original may be admissible. Board of Education's loss of application forms and other application materials of plaintiff alleging employment discrimination in violation of city municipal code and federal regulations requiring that such records be maintained was more serious than mere laxity or oversight, but did not amount to bad faith. Plaintiff claimed originals of artwork allegedly appropriated by defendants were destroyed in flood. But neither plaintiff nor any other witness offered by plaintiff could explain source of water. There being no evidence of any rainfall during the time at which damage allegedly occurred, nor of any leakage from any household plumbing or any other plausible explanation for extensive water damage suffered. Hey, that's the Lucasfilm one again. Appropriate by this. Oh, Lord. So they the defense appropriated it, and then they said we're destroyed in the flood. Original not obtainable, section 1056. Where no original can be obtained by any available judicial process or procedure, the original is not required. And other evidence of the contents of a writing, recording, or photograph is admissible. However, the proponent of the secondary evidence must produce some evidence which has a logical tendency to establish the non-availability of the original. For example, when the original is in possession of a third person, the inability to procure it from that person by resort to process or other judicial procedure, including a subpoena, duces tecum, as in, we went over this one before, didn't we? But I forgot what it meant. So you know what that means. Duces. That's at the end of the D's. If anyone knows in the chat wants to pipe up the definition, feel free to do that. See if you can beat me to the chase here. Wow. DEs. Okay. getting there. Dram shop, place where alcoholic beverages are sold. Okay. All right. Okay, we're almost there. Dual, do cut. No, it says do cease. Do. Well, let me see. Also, take them. Duces, take them. Duces, take them. Bring with you. See subpoena. Under subpoena. Bring with you. Duces, take them. Okay. Duces, take them. Subpoena. Including a subpoena, duces tecum as an incident to the taking of a deposition in another jurisdiction, is sufficient explanation of non-production. No further showing is required. When a subpoena has been served on the parties but the original has not been produced in response to the subpoena, Federal Rule of Evidence 10042 standard of unavailability has been met. See, whether the subpoena issued is a trial subpoena or a grand jury subpoena makes no difference. Under Rule 10042 of the Federal Rules of Evidence, a police officer's testimony as to the serial numbers of $10 bills examined at the defendant's residence has been held admissible where the bills could not be found when the police officer returned to the residence with a search warrant, and where even assuming that the defendants were amenable to a subpoena directing the production of the bills at trial, it would be unrealistic to expect that they would readily produce the bills that would have made the prosecution's case against them complete. Jeez, serial numbers. Okay. All right, original in possession of opponent, Section 1057. The original is not required, and secondary evidence of the contents of a writing, recording, or photograph is admissible if at the time when an original was under control of the party against whom the document is offered, that party was put on notice, by the pleadings or otherwise, that the contents would be a subject of proof at the hearing, and the opponent does not produce the original at the hearing. Under Rule 10043 of the Federal Rules of Evidence, in order for secondary evidence to be admitted under such circumstances, the proponent must establish 1. Possession or control by the opponent, 2. Demand or notice made by the proponent signifying that the document will be needed, and 3. Failure or refusal by the opponent to provide the document in court. So the original is not required, and secondary evidence is admissible if at the time when original was under control of the party, that party was put on notice. Against the document is offered, that party was put on notice, and the pleadings or otherwise the contents will be subject of proof at the hearing, and the opponent does not produce the original at the hearing. Okay, so here we get a little bit more clarity here. See, once again, under Rule 10043, in order for the secondary evidence to be admitted, the proponent must establish possession or control of the opponent by the opponent, demand or notice made by the proponent signifying that the document will be needed, and 3. Failure or refusal by the opponent to provide the document in court. So a party who has an original in his or her control has no need for protection of the rule requiring an original, if put on notice that proof of contents will be made, since the party can ward off secondary evidence by offering the original. Notice to produce original documents on which action is based. Use of secondary evidence on failure to produce. to notice to produce documents. So this is interesting stuff here too. When there's failure to produce documents, especially they've been put on notice to preserve them and they're in possession, yet they do not want to relinquish them, and they're trying to use them as evidence against you, then there's that secondary evidence you could use. Possibility of prejudicial nature of documents requested. Requested documents not in possession of defendant. So this is under form evidence forms, practice of pleading forms. Request for disclosure too broad. Availability of pretrial conference of information requested. So this is all good Esquire stuff here. And we're on to section 1058, issues of fact for court or jury. The admissibility of secondary evidence, including whether a proponent has demonstrated the foundational requirements and whether the proponent has made sufficient showing of the search for the original documents and of the fact of loss of the originals, is a determination to be made in the discretion of the trial court. However, the issue is for the trier of fact to determine, and in the case of other issues of fact, when an issue is raised to 1. Whether the asserted writing ever existed. 2. Whether another writing, recording, or photograph produced at the trial is the original. Or 3. Whether other evidence of contents correctly reflects the contents. Thus, the question whether the loss of originals has been established or the fulfillment of other conditions specified in Rule 1004 of the Federal Rules of Evidence is for the judge. But Rule 1008 is meant to ensure that the jury, rather than the court, decides a preliminary question of fact when it goes beyond the mere administration of the rule preferring the original as evidence of contents and into the merits of the controversy. Under Rule 1008 of the Federal Rules of Evidence, the court decides the preliminary questions as to the lack of an original and whether the proponent has presented sufficient foundation so that a reasonable juror could be convinced that the secondary evidence offered correctly reflects the contents of the original. However, where a plaintiff offers secondary evidence of the contents of an alleged contract after first introducing the evidence of the loss of the original, and the defendant counters with evidence that no such contract was ever executed, a jury question is raised as to the existence of the contract by reason of Federal Rule of Evidence 1008.96. No, 1008. This is footnote 96. This decision is not one for uncontrolled discretion of the jury, but is subject to the controlled exercise, generally by a judge, over jury determinations. Instructions. Thus, proof of routine practices may compel an inference that the original did in fact exist and may be a factor considered by the court in ruling upon the admissibility of secondary evidence. Routine practices may compel an inference that the original did in fact exist and may be a factor considered by the court in ruling upon the admissibility of secondary evidence. Here's that Lucasfilm case again. Interesting. The trial court did not abuse its discretion in admitting testimony as to the contents of letters written to the witness in which the defendant confessed to a murder. Testimony that the witness had thrown the letters away established a sufficient excuse for the failure to produce the originals. Wow. As to proving loss or destruction of the original document without bad faith on the part of the proponent. Okay, we saw that part. Let's see. Relevancy of evidence depends on the fulfillment of a condition of fact. The court shall admit it upon or subject to the introduction of evidence sufficient to support a finding of the fulfillment of the condition. Nice. Evidence of a routine practice of a conveyor in reserving a mineral interest in property transferred is relevant to prove conduct under Federal Rule 406 and is admissible in lieu of the original deed under Federal Rule 10041. Wow. Now we're on to the admissibility of summaries, section 1059 generally. Under the best evidence rule, a witness may give summary based on the inspection of a number of documents, or the summary itself may be admitted in evidence if the underlying documents are so numerous and intricate as to make an examination of them in court impractical. The underlying documents themselves are competent as evidence, and the underlying documents are made accessible to the opposing party so that the correctness of the summary may be tested on cross-examination. Practice guide: the party seeking admission of a summary must give a reasonable notice to the opposing party of its intention to use the summary as evidence. The trial court has broad discretion in admitting or rejecting summaries and in imposing conditions under which they may be admitted. The testimony of an accountant or auditor is frequently admitted as summary evidence of documents or books where the accountant or auditor has examined such documents and is able to testify as to their contents. That's why it's important to examine documents, public records, so you're able to testify to their contents in case there's any kind of funny stuff that ever goes on. A recapitulation of computer printout sheets was not admissible on behalf of the plaintiff, the assignee of an open account who sought to recover charges on the account, where although the plaintiff's witness testified that the original invoices were available, she did not review them, where no attempt was made to produce or explain the failure to produce the original invoices in court, and where production of only the required 11 invoices would not be burdensome to the plaintiff. Recapitulation of computer printout sheets. I like that statement there. A summary of scale tickets showing deliveries of corn at an elevator during a period when a farmer alleged that a grain elevator company was refusing to accept corn, and a summary of contracts between other farmers and the company for delivery of corn during the relevant period were not admissible in a contract action between the farmer and the company, since the scale tickets themselves were hearsay, and contracts with other farmers were irrelevant. Hey, that's good. That's a real good one there, too. The Crowder versus Aurora Cooperative Elevator Company. So claims, surety under surety bonds, inadmissible. Okay, well, these get mind-numbing there. See, trial court erred excluding an auditor's summary of an examination of defendant's corporation's records on the ground that the records themselves were the best evidence of the defendant's business transactions, where plaintiff showed that the auditor was a qualified witness who had examined the defendant's records, and that the records were so voluminous that their production was impracticable. So the trial court erred in excluding the auditor's summary. So the appellate court threw it back. So, under Rule 10.1006 of Federal Rules of Evidence generally. Under Federal Rules of Evidence, the contents of voluminous writings, recordings, or photographs which cannot conveniently be examined in court may be presented in the form of a chart, summary, or calculation. The originals or duplicates must be available for examination, copying, or both by other parties at a reasonable time and place, and the court may order that they be produced in court. Since only writings, recordings, or photographs may be the subject of Federal Rule of Evidence 1006 summary, such a summary cannot properly incorporate a witness's personal knowledge as the basis for any of the matters summarized. Thus, Federal Rule Evidence 1006 does not authorize the admission of summaries of testimonies of an out-of-court witness, and a witness may not present an oral, generalized review of records which have not been admitted in evidence, unless one of the other specific exceptions to the best evidence rule is shown to be applicable. Federal Rule of Evidence 1006 does, however, authorize a non-expert witness to summarize documentary evidence already presented by other witnesses. The mere fact that documents at issue are already in evidence assures neither that they can be conveniently examined in court nor that they had been examined in court. An exhibit containing summaries of other exhibits and evidence may be admissible under Rule 1006, even though the other exhibits could have been and were examined at the time of their admission, where such other exhibits are numerous and would be difficult to comprehend without the summary exhibit. Practice Guide. While the better practice is to require that summary charts be prepared by the witness, the fact that they were not prepared by the witness does not prevent their use, where this does not hamper the opponent's ability to cross-examine the witness, and the opponent is not prejudiced. Nor does Federal Rule 1006 require that a summary be prepared by someone independent of the party offering the summary. When a chart does not contain complicated calculations requiring the need of an expert for accuracy, the witness who presents the summary chart needs no special expertise. But there's a caution: summary charts can be misused, and a trial judge must carefully handle their preparation and use so as not to confuse or mislead the jury. Here's under Rule 1006 Supplement. Case authorities: testimony about narcotics RICO defendants' new worth based on defendants' abundant financial records was properly admitted as summary testimony of voluminous evidence, all that money, to corroborate evidence of the defendant's unexplained income. It was not subject to the same rigorous evidentiary requirements applicable to tax evasion cases, since net worth in tax cases goes to the element of offense, while in drug prosecutions it is corroborative only. In action by commercial lessor to recover amounts due under lease. Trial court erred in admitting, on behalf of lessor, summaries of 36 monthly statements reflecting charges for base rent, common area fee, insurance, property tax, merchant dues, and any payments made by lessee. Original records were at no time produced by the lessor, but Rule 1006 requires that the party offering summaries make records available to the other party's satisfaction. Oh, that's a good one, to their satisfaction, not just for examination. Federal Rule 1006 does not require that it be literally impossible to examine the underlying records before a summary or chart may be utilized, or even that it not be feasible to admit the records into evidence. All that is required for the rules to apply the underlying writings be voluminous, and that in-court examination may not be convenient. Of course, the underlying supporting data still would have to be provided for examination and cross-examination. Right, let's see here. Summary evidence may be admissible even though not all underlying documentation has been admitted. So long as underlying evidence is admissible and available to the opponent, so that proper cross-examination may be had. All right, and here are the rest of those there, and we're on section 1061, summaries as evidence, which jury must consider. Although the word evidence does not appear in the text of the Federal Rule of Evidence, Rule 1006, summaries may be treated as evidence under this rule where, in the court's discretion, examination of the underlying documents in a trial setting cannot be done conveniently. This construction of Rule 1006 is compelled by the rule's history and by the fact that the rule requires only availability of the underlying documents. Where the underlying documents are introduced as well as summaries, the court may instruct the jury that the summaries and the witness's explanation of them are not evidence in and of themselves, and that if the summaries do not correctly reflect the underlying evidence, and the jury should disregard them. The court may do this in order to ensure that the jury will not rely on the conclusory matter in the summaries as independent proof of a defendant's guilt, and thus prejudice the defendant's trial. Summaries may be admissible in order to show what the underlying documents do not contain, where those underlying documents would not have been admissible for the same purpose. Some courts take the position that pedagogical charts are not themselves evidence, and absent the consent of all parties should not be sent to the jury room with other exhibits. So no your pedagogical charts in the jury room, please. Elsewhere, however, a pedagogical summary can itself be admitted in evidence where the trier of fact will find it helpful and will not be unduly influenced by the exhibit. Helpful and not be unduly influenced. If a summary of a pedagogical chart is sent to the jury, it should be accompanied by a limiting instruction which informs the jury of the summary's purpose and that it does not itself constitute evidence, so it's not mandatory. Caution, because summaries are elevated under Rule 1006 to the category of evidence. Care must be taken to omit argumentative matter in their preparations, so that a jury will not be led to believe that such a matter is evidence of the assertion it makes. Ooh, big one there. All right, there's our case holdings. Lots of them there. And we're on to 1062. Under other provisions of Federal Rules of Evidence, where the requirement under Rule 1006 of the Federal Rules of Evidence that the underlying materials must be made available for examination or copying cannot be met because those underlying materials are unavailable, it may be possible to admit the summary as secondary evidence of the underlying materials if the requirements of the lost or destroyed exception under Rule 1004 or the public records exception under Rule 1005 are satisfied. So there's a public records exception, 1005. There is no authority for allowing a summary of purely testimonial evidence, which, strictly speaking, cannot be said to come within the requirements of Rule 1006, but could be allowed under Federal Rule 611A, under which a court is required to exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to 1. Make the interrogation and presentation effective for the ascertainment of the truth, and 2. Avoid needless consumption of time, and 3. Protect witnesses from harassment or undue embarrassment. Practical guide, where some of the underlying materials are unavailable and some unavailable, the summary can be admitted partly under Rule 1006 and partly under Rule 1004 or 1005. Partly. Interesting there, too. All right, let's check over here to the chat as we get to the next section, to the court discretion. Yeah, some pretty good info here. It's pretty dense, so salute to you all that can stick with us here. I see someone's paying attention here. Pedagogic. That's a hard word to say here. Pedagogical. I don't know how you pronounce it properly. Pedagogical. I guess that's it. Pedagogical. Okay, well, that's what I see here in a dictionary. Pedagogical. But it's, one of those words we don't need to say. All right, let's continue. Section 1063, Court's discretion. The admission of a summary rests within the sound discretion of a trial court, and a decision whether to admit a summary will be reversed only for an abuse of that discretion. Oh, so once it's in there, unless it's abused, it doesn't get reversed. There can be no abuse of discretion if the requirement of providing a reasonable time and place reasonable time and place to examine the originals or duplicates by opposing parties is compiled with, if a proper foundation as to the accuracy and authenticity of summaries is laid, and if use of the summaries would save the court much time and inconvenience. A reasonable time and place to examine the originals by opposing parties is complied with. Not compiled, complied. Okay, now it makes sense. Even if it is determined that the trial court abused its discretion in allowing the use of summary charts, it may be that no reversible error will be found if the reviewing court determines that the defendant was not prejudiced, because full cross-examination in the trial court's admonitions to the jury serve to minimize the risk. All right. Of prejudice. The court has considerable discretion in determining whether the volume of the underlying documents is sufficient for the rule to apply. So, each case. Here we go. The trial court in an embezzlement prosecution properly exercised its discretion to admit a spreadsheet summary of an automobile dealership's transaction records as evidence that a clerical employee had been skimming cash payments made on car purchases, where the underlying materials were voluminous, and a general correlation between the records and the summary was established by the testimony of several car buyers whose cash payments were not reflected in the dealer's books, notwithstanding that the summary reflected hearsay reports to the manager who prepared the summary. Of course, you prepared it, skimming all that money. Foundation requirements, section 1064. Right. Summaries are admissible only when a proper foundation has been laid. This involves making the underlying documents available to the opposing party for inspection and showing the admissibility of the underlying documents. A proper foundation for the introduction of a summary may be established through the testimony of a person who is responsible for the summary's preparation or the person who supervised preparation of the summary. No adequate foundation is laid for the admission of a summary or list where the person offering the summary or list is unable to testify that such summary or list accurately reflects and summarizes the underlying material. One proper method of laying a foundation for admission of summary charts is to admit the documentation on which the summary is based. So, foundation requirements, case authorities. Union's accounting summary of defendant employers' payroll was properly used on summary judgment motion in Union's action seeking unpaid ERISA benefit contributions, which would have survived evidentiary attack at trial after proper foundation and showing of purpose for which it was offered. And here we go, section 1065, making underlying documents available. Rule 1006 of the Federal Rules of Evidence requires as a foundation not only that the contents of the writings, recordings, or photographs be voluminous and inconvenient to examine in court, but also that the originals or duplicates be made available for examination or copying by other parties at a reasonable time and place. Unlike the original documents, the summaries themselves need not be made available in advance of trial. Unlike original documents, the summaries need not be made in advance of trial. Ordinarily, the reasonable time within the originals or duplicates of the underlying materials must be made available will be at some point before trial, since the object is to give opposing counsel a meaningful opportunity to prepare challenges to the materials. However, the trial court may permit the matter to be dealt with during trial. Ooh, so you can spring the summaries at the last minute. Looks like here, as long as you gave them the voluminous data in advance. Yeah, that's what it looks like. If the underlying documents are in fact made available for inspection, the requirement of the rule is satisfied even if the opposing counsel fails to take the opportunity to review the documents. The right to examine the underlying data can be waived if it is not raised in a specific and timely fashion. Ooh. A computer printout of the information contained on a diskette. I guess that'd be a dot matrix printout of the information contained on a floppy diskette, perhaps, constitutes a duplicate within the meaning of the Federal Rule of Evidence 1006 requirement that originals or duplicates of information contained in charge summaries or calculations must be made available for examination, copying, or both at a reasonable time and place. Where the proponent of a summary cannot provide the opponent with the underlying documents because they no longer exist, a summary exhibit is inadmissible. Beautiful. And here's a little comment. The framers of Rule 1006 of the Federal Rules of Evidence clearly contemplated a pre-trial resolution of any issues that may be raised concerning the use of summaries. The rule, by requiring that the underlying documents be made available to opposing counsel, encourages counsel to eliminate objectionable material and matter and to stipulate the form of the summary. Nice. Encourages to eliminate objectionable matter and to stipulate to the form of the summary. This process greatly reduces the frequency of such objections as the prejudicial effect of summaries. Here we get the composite videotapes allegedly showing a televangelist's attempts during broadcast to solicit funds were properly admitted into evidence, notwithstanding that the original broadcast tapes totaling over 200 hours were not introduced. Since it was undisputed that the defendant's counsel had access to original broadcast tapes at least 6 months prior to trial, and requiring government to formally introduce underlying tapes and evidence would have served no useful purpose. Was criticized on other grounds. Imagine having to watch 200 hours of a televangelist attempting to solicit funds from you. That's a punishment in and of itself. Cruel and unusual. Forms, stipulation, admitting documents or copies or abstracts thereof and waiving rule to introduction of documentary evidence. Woo. And here we go, Section 1066, showing admissibility of underlying documents. Let's jump over here to the chat and see if I think it should be refreshing. I hope it is. Let me just double check here. And it looks like we're all up to date. And we're good to keep going. As a condition precedent to the admissibility of evidence of a chart summary or calculation under Rule 1006 of the Federal Rules of Evidence, the proponent of the exhibit must lay a proper foundation for the admission of the general materials on which the exhibit is based, or for the parties to stipulate as to the admissibility of the original materials. Since the proponent must establish that the underlying documents are themselves admissible, the same general foundation must be laid, as if the underlying materials were actually being offered in evidence, minus the sort of item-by-item in-court identification which ordinarily attends that process. All right. The general foundation, as if. Okay, a summary may be excluded if the underlying evidence is inadmissible because it is irrelevant. Good. Moreover, a summary based on underlying hearsay documents is inadmissible unless a proponent can demonstrate the admissibility of underlying materials under an exception to the hearsay rule, such that under Federal Rule of Evidence, Rule 803, Section 6, for records kept in the ordinary course of business, the public records exception, or the exception under Federal Rule 803-24 for statements not specifically covered by any of the other exceptions, but having equivalent circumstantial guarantees of trustworthiness. A showing under Federal Rule 8036 must be made by the custodian of the documents, or by some other qualified witness. A summary of both inadmissible and admissible hearsay should not be admitted under Rule 1006. The proponent is entitled to admission only of those portions that he or she can demonstrate are entirely admissible, because if it's not, it needs to go to trial for that. Similarly, charts which are derived from exhibits that have been held inadmissible at trial are inadmissible in a post-trial proceeding in the case. Observation: exhibits admitted under Federal Rule 1006 which merely summarize the information Okay, exhibits under Federal Rule 1006, which merely summarize the information received by the jury through oral testimony or other exhibits received into evidence, do not constitute hearsay. Ooh. Although the underlying documents must be admissible, in order to establish a foundation for the summary, they need not be admitted into evidence in every case, since an absolute requirement of admission would be at odds with the last sentence of the Rule 1006, providing that ordering the materials to be produced in the court is discretionary within the trial judge. Again, they have wide discretion. And here's our practice guide. If summary evidence is independently admissible in its own right, such as business record under Rule 8036, there is no need to comply with 1006 in order to have the evidence admitted. And here's some more on Section 1066 showing admissibility of underlying documents. The trial court should not have considered affidavits as proof that the intent of the parties to insurance contracts was other than that appearing on the face thereof in an action determined which of two excess insurance clauses applied. The pleadings do not contain any allegation of fraud or mistake, and the policy as written is not ambiguous. Use of the word valued rather than valid does not make the meaning of the INA's clause uncertain, because valued is a term of art which is used to describe a particular type of insurance. Wow. They play some word trickery there, huh? Valid or valued. Sounds more like a dictation error. I don't think they had real good voice to text. See, 98. Yeah, it was a little primitive back then. Voice to text. Okay, and let's see here. Hearsay evidence. Then we have the accuracy of the charts, summaries, and calculations must accurately reflect the underlying documents. They need not be encyclopedic, reasonably accurate. Okay, so we get this part here. Your little charts. When the figures on a chart have not been properly established and keyed to the underlying evidence, a cautionary instruction may be inadequate to avoid prejudicial error. So it shouldn't be admitted, is what they're saying. So no shifty charts. And here you go, the distinction between Federal Rule 1006 summary and pedagogical devices. See here, a summary admitted under Rule 1006 of the Federal Rules of Evidence must accurately reflect the contents of the underlying documents and must not function as a pedagogical device that unfairly emphasizes part of the proponent's proof or creates the impression that the disputed facts have been conclusively established or that inferences have been directly proved. Wow. I see here. So the charts or the summaries can't be used to unfairly emphasize proof, like conclusively establishing disputed facts or inferences are being directly proved. So definition, a pedagogical summary is simply a demonstrative aid which undertakes to summarize or organize other evidence already admitted. An expert witness may present a summary of one side's case based on testimony and physical evidence previously admitted. Under such circumstances, it is proper to instruct the jury that the summary is not evidence, that the accuracy and reliability of the summary is to be determined by the testimony and exhibits admitted into evidence, that the expert's opinion is to be offered only under such weight as the jury feels it deserves, and that they could disregard the expert's opinion entirely. Such evidence has been admitted against objections that it improperly emphasizes and repeats the party's evidence that unlawfully bolsters the credibility of the party's witnesses. Some summaries partake, fancy charts, right? Some summaries partake of the nature of both a Rule 1006 summary and a pedagogical device. A party's assumptions included in a summary do not make the summary inadmissible. Assumptions included in the summary do not make the summary admissible so long as the underlying supporting evidence has been previously presented. So this is a good way you can slick in assumptions, huh? Not presumptions, but assumptions. So, interesting little splitting of hairs we should probably check on. If we were to check on assumption as opposed to presumption from a legal perspective, I just passed it. Shoot. Friendly amendment and hostile amendment. Oops. All right, we'll be there shortly. Oh, man. All right, here we go. We're on the asses here. Assets, assignments, association, assume. Wow, here's an interesting word here. Assumpsit. He undertook an express or implied promise. Common law action for breach of such promise. Wow, a lot of assumpsits here. Okay, assumption from the 13th century. A fact or statement taken as true or correct. A supposition. 2. The act of taking. For on oneself. The agreement to so take. The assumption of a debt. So assumptions, to take, huh? The act of taking, to assumed assumption. And a presumption, maybe we just luck out and get really close to it. Takes a moment to catch up here after that radicals move through the document. Here we go. Yeah, we might be pretty close to it here. All right, pre-trial, pre-tax, presumption. Lots of presumptions here. At least we want the general definition. 15th century, so a little bit newer. A legal inference or assumption that a fact exists based on the known or proven existence of some other fact or group of facts. Most presumptions are rules of evidence that call for a certain result in a given case unless the adversely affected party overcomes it with other evidence. A presumption shifts the burden of production or persuasion to the opposing party, who can then attempt to overcome the presumption. So it's a little bit different. A legal inference or assumption, but not in the legal sense, it seems here. A presumption may be defined to be an inference as to the existence of one fact from the existence of some other fact found upon a previous experience of their connection. So again, assumption and presumption, quite different here. Although here's a little trickery they'll play right here, is using it not as the terminology, but as a standard definition of assumption here with the or. But once you get past this, none of this is similar to what we read about the taking, the assuming, the assumption, take on. All right, enough of that digression. Let's proceed with the book. Okay, so in this case, a party's assumption, so when they take on, when they include it in a summary, do not make the summary inadmissible. So this looks like more of not a terminology here. So long as the underlying supporting evidence has been previously presented to the jury, the court has made it clear that the ultimate decision as to what weight should be given to the evidence is for the jury, and the opponent has the opportunity to challenge the assumptions or conclusions on cross-examination. So, projections of future lost profits are not admissible as summaries, since they are interpretations of past data, and projections of future events are not a simple compilation of voluminous records. However, such projections may be admissible as opinion testimony, right, because they can be used for extrapolation. Back here, geez. Summary charts, fairly summarized evidence, are used as an aid in understanding the testimony already introduced, are admissible where the witnesses who prepare the chart is subject to cross-examination. All right. And that takes us to the end of this section. Next time, we're going to continue with the application of the best evidence rule to particular types of evidence. And we're going to start with tape recordings. I don't think they're referring to Scotch tape. Well, that takes us to the end of this presentation. I'd like to thank everyone for coming in here and sharing the time to go through the law of evidence and the best evidence rule. I know it's been pretty light on the notifications and getting the word out there, but I'm glad everyone could attend that did. I hope you all learned a little something from this. And yeah, please hit the like on your way out so that other people can know that there's some good information here, and that if there's any benefit anyone gets, that would be beneficial to all of us that are expressing our duties here to actually utilize the courts for our benefit and make sure controversies remain in the proper venue where they should. With that said, let's move on to the end of our presentation here. We're going on to 54 Stat, section page 178, chapter 183, with a joint resolution that was proclaimed in the preamble on May 3rd, 1940, which has yet to be repealed in any way, so it still stands as law, as we see here under the public laws. The joint resolution authorizing the President of the United States of America to proclaim, "I am an American," Citizenship Day for the recognition, observance, and commemoration of American citizenship, and the preamble, which still stands to this day. Whereas some 2 million young men and women in the United States each year reach the age of 21 years, and whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance. Hang on a second. Here we go. Whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. Therefore, be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled, that the third Sunday in May each year be, and hereby is, set aside as Citizenship Day, and that the President of the United States is hereby authorized and requested to issue annually a proclamation setting aside that day as a public occasion for the recognition of all who, by coming of age or naturalization, have attained the status of citizenship, and the day shall be designated as I Am an American Day. That the civil and educational authorities of states, counties, cities, and towns be, and they are hereby, urged to make plans for the proper observance of this day, and for the full instruction of future citizens of their responsibilities and opportunities as citizens of the United States and of the states and localities in which they reside. So you see here, not just citizens of the United States, citizens of the United States. They're not saying United States citizens, and of the states and localities in which they reside. Nothing herein shall be construed as changing or attempting to change the time or mode of any of the many altogether commendable observances of similar nature now being held from time to time, or periodically, but to the contrary, such practices are hereby praised and encouraged. So all the commendable observances of similar nature are hereby praised and encouraged. Either at the time, this is section 2 here, of the writing of decree of naturalization, or other such time the judge may fix. It also says here, it is being the intent that the purpose of this section is to enlist the aid of the judiciary in cooperation with civil and educational authorities and patriotic organizations in a continuous effort to dignify and emphasize the significance of citizenship. And the citizenship, this is approved May 3rd, 1940. And patriotic organizations in a continuous effort to dignify and emphasize the significance of citizenship. And of course, they are talking about the sovereign citizens of our nation. That's the citizenship they're referring to. The I Am an American Citizenship Day. So, that said, just want to make sure everyone is aware that they have, the only part they've repealed is the actual day. It's no longer the third Sunday in May. I think it's September something. I think they moved to Constitution Day. They put it on the same day for some reason. But nonetheless, it is still standing law. So this is something to be aware of, and something to also to contemplate the importance and significance of those responsibilities that are impressed upon the sovereign citizens of our nation. Okay, now with that said, I'd like to thank you all for attending, and I hope to see you all on the next one. Peace out.